We're starting this edition with our top focus. The teen accused in the Pune Porsche accident case must be released from detention immediately. The Bombay High Court has ruled today. The 17-year-old boy's late-night dash in a Porsche on May 19th had left two engineers dead and had sparked an nationwide outrage. Now, the court has observed that the JJB's order, that's the Juvenile Justice Board's order, remanding him in an observation home was illegal and passed without jurisdiction. Well, it has clarified that the teenager is under rehabilitation and had been referred to a psychologist, and these sessions must continue. The court has said that the CCL, that is a child in conflict with law, is under 18 and his age needs to be considered. Well, this ruling came after the petition was filed by the boy's aunt, who had sought his release from a government observation home, and this is a big order coming in from the Bombay High Court. The Bombay High Court, observing that the minor's arrest was illegal, has ordered immediate release of the teen in the case. My colleague Radhika joins us on the broadcast, getting us more on that. Radhika, big order coming in from the Bombay High Court. The Bombay High Court, in a strong observation that was made in the court, said that the minor's arrest is illegal. It does put a question mark on how the police has really pursued this case so far.
Certainly significant development as far as Pune Porsche case is concerned. Bombay High Court asking, in fact, ordering for the release of the minor accused. In fact, it has called the entire remand illegal and arbitrary. We're joined by the lawyer of the accused family at this point, Prashant Patil. Mr. Patil, first and foremost, take us through the observations made by the court and what were some of the contentions that you had put forth in that particular petition.
See, we had moved a writ of habeas corpus in this matter. If you look at the scheme of the Act, Section 12 of Juvenile Justice Act is the backbone of the Act. What does that section say in a very layman's term? Be it a bailable section or a non-bailable section. A child in conflict in law cannot be detained because the scheme and the code of CRPC, that is the Criminal Procedure Code, is not applicable to the child in conflict in law. So on 19th May 2024, when the child in conflict in law was released on bail, it does not matter what sections were applied against him. The fact remains, according to the scheme of law, he has to be released immediately. So on 22nd May 2024, on 5th June and on 12th June 2024, there were 3 orders passed by the Juvenile Justice Board ordering the detention, quote-unquote detention of the child in conflict in law at an observation home. Our case was very simple, that based on purely on law, according to the scheme of the Act and the guidelines of the Honorable Supreme Court, the child in conflict in law cannot be detained in the manner through which in this matter he has been detained. That's why we moved a writ of habeas corpus. The paternal aunt of the juvenile, as in the child in conflict in law, moved this particular writ. Our arguments were put across by the counsels, and then the other side prosecution argued against us aggressively. Today the Honorable High Court has specifically directed the immediate release of the child in conflict in law because the rule of law is supreme. The legislatures have been very clear according to Section 12, and we are based on that.
Some of your contentions have been agreed upon by the court. Court has said one should consider his age and not just the seriousness of the case, and also that he is under reference of a psychologist. So what about his rehabilitation process? Of course, he will be with his aunt, I believe. When will the release happen, and what about his rehabilitation henceforth?
See, since 19th May till date, almost 3 to 4 psychologist sessions he has undergone, the child in conflict law has undergone. The Honorable High Court has directed to continue with the psychologist sessions because that is the scheme of the Act. The Juvenile Justice Act, the main purpose of the Act is, the preamble of the Act says, the child-friendly atmosphere has to be maintained, and we have to ensure, we as in the society has to ensure that the child in conflict in law comes back to the mainstream. So for that, this particular psychology sessions have to be continued. That are the directions of the Honorable High Court.
All right. So thank you, Mr. Patil. So the lawyer of the family, in fact, explaining to us the contentions made in that particular habeas corpus petition and the observations made by the court while ordering the release of the juvenile, and also pointing at the rehabilitation measures that have been directed by the court as well. So court here saying that this entire order by JJB was illegal, arbitrary, and they did not have the jurisdiction to put him back or put him behind bars, or rather in an observation home, when a bail order was already in effect. Of course, the cops are trying to treat him as an adult. So whether that will happen
Right.
in the days to come, that remains to be seen.
Right.
So at this point, of course, this is a setback for Pune cops, but certainly a relief for this juvenile accused.
All right. Thank you so much, Radhika, for getting us all those details there.